Well, the government's regulation of water on private property has a long history of controversy for farmers and ranchers. A 2022 court case involving a South Dakota farmer and a puddle in his farm field underscores confusion of the USDA wetland certification. Roger McEowen with the Washburn School of Law joins us now with further perspective. Roger, good to have you with us. Very timely topic. Can you give us a recap of the situation and the matter at hand?
Yeah, you're right, Tammy. Good to be with you. This was a South Dakota farmer in southeast South Dakota who had an 1/8 of an acre puddle in his field that USDA certified as a wetland in 2011 under the Swampbuster rules, which meant that he couldn't drain it without forfeiting farm program benefits. That wetland was about 8.5 inches deep. Of course, it's just 0.8 of an acre, but only at certain times during the year, basically in the spring after snowmelt. And ironically, it was the result of a tree belt that his grandfather had planted in 1936 to prevent soil erosion. So it was a soil conservation tree belt that had been put in. And so snow would accumulate as that had matured over the years. The trees got bigger. Snow would accumulate around the tree belt in the winter. It would melt in the spring. And that's what would create the 0.8 of an acre wet area in a low spot in the field that didn't drain. It would just about half the time saturate into the ground, and he could farm it. Other times he had to drain it off so he could farm the field, but USDA said, no, you can't do that.
So talk a little bit more about what the USDA's position is on that type of wetland.
Yeah, they refuse certification. Now, the statute actually is pretty clear. You have a right to get a review of a final determination. You can have the certification reviewed by statute. But the USDA said, no, our reg says that to get a review of a certification, you have to show a natural event changed the topography or the hydrology of the wetland, and that caused the original certification to be no longer valid. And so that was the USDA's position, that their regulation superseded the statute.
And so where do we go now? What was the lower court ruling?
Yeah, the trial court in South Dakota on the arbitrary and capricious standard said that the USDA did not act arbitrarily or capriciously, and they're creating a rule of requiring some type of new evidence as a prerequisite to have a certification reviewed was fine.
And so, of course, now we're waiting on the Supreme Court to rule, and we're waiting for some more answers. And I know that this is a huge issue for farmers and ranchers everywhere. So what is the big takeaway for farmers and ranchers as we move forward?
Well, we're waiting for the Supreme Court to review the Sackett case out of Idaho on WOTUS, which is separate than Swampbuster. We're waiting on the Eighth Circuit to review this case and issue an opinion. But the Swampbuster rules are complex. It'll be interesting to see what the appellate court says about the USDA regulation and whether it's actually consistent with the statute.
Oh, wow. Very interesting. Yeah, those are two very similar issues there. But I appreciate you keeping us straight and straightening us out on that. Both very serious for our farmers and ranchers. That's Roger McEowen with the Washburn School of Law. Appreciate you joining us today.